Hi, this is Ed Sullivan and Marco Berti talking about Sarbanes-Oxley, or SOX. Mark, what in the world do litigation hold notices have to do with SOX?
Well, I wouldn't have guessed a whole lot until I read this case, Mendez versus Halliburton, from right here in Houston, Texas, decided by the ARB late last year. What happened in that case is really kind of common, I would think, but it landed the company Halliburton in significant hot water. And here's what happened: is Mr. Mendez had regarded himself as somebody in accounting who saw some fraud afoot at Halliburton, or he thought so. So he made a complaint. He made an internal complaint, and then he made a complaint to the SEC. Well, when he made the internal complaint, he identified himself, of course. That had been rejected. He went to the SEC. So when Halliburton got the notice from the SEC, even though it was anonymous, they knew it was Mr. Mendez. Now, naturally, having gotten that complaint from the government, the general counsel comprised a litigation hold notice and said, hey, Mr. Mendez has brought this complaint. If you have your emails, preserve them, all that sort of stuff that you would see in a litigation hold notice. Well, Mr. Mendez was still working for the company, and he says after that litigation hold notice was sent, he was ostracized, he was kept out of meetings, he was reduced to barely a nub of a man at the company, and he said it was the worst day of his life. So he sued the company after he quit, and was thrown out by the administrative law judge, but it went up to the ARB, and the ARB said, well, you know, Mr. Mendez, you were not constructively discharged when you quit, so you have no claim for that. But then they said, remarkably, the disclosure of his identity to the others at the company in the litigation hold notice violated SOX's confidentiality provision and gave him an independent claim for that alone, and remanded the case to the administrative law judge. So a remarkable holding that Halliburton certainly could have never foreseen when they sent that litigation hold notice.
Well, hold on for a second, Mark. How could the company have engaged in litigation hold procedures if they couldn't even identify the person who made the complaint?
Well, that's why it's good to be the judges up there at the ARB, because they didn't have to opine on that, and that's left for companies to figure out themselves. But there may be some workaround, but the issue I just identified is why this is really kind of a Gordian knot situation here, and really put the company in a difficult position, arguably very unfair.